I got the radiology facility to admit something during a deposition that they denied throughout the entire litigation. You want to learn what this was? Come join me as I share with you this remarkable information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. So here's a scenario. A woman with a breast lump goes to a radiology facility in order to get evaluated. She's told to have a sonogram, an ultrasound of the breast, as well as a mammogram. So here's what I asked the radiology technician. In a patient whose ultrasound was negative, but they came in with a palpable lump, what is the procedure that your office follows at that point? And now she told me that the radiologist, the doctor who reads and interprets these films and these studies, are always required to come into the patient to now do a physical exam on the patient and then repeat the ultrasound examination. This way, now you have an attending physician who's going ahead doing a repeat exam, feeling clinically for themselves where the breast lump is and what's showing up on the ultrasound. So now I got this particular person to admit that. And now, about a month later, I had an opportunity to question the supervisor in the same radiology facility. And I again asked the same question. It was all about protocol. I said, ma'am, what happens in a situation where a patient, especially a young patient, comes in with a palpable mass and now the sonogram is negative? What are you supposed to do? What are the people in your facility supposed to do at that point? And what she tells me is that the doctor, the radiologist, is always supposed to come into the patient, physically examine the patient, and then do a repeat ultrasound scan on his or her own. This way, they get an idea and a sense of whether or not the technician's scan was accurate. Perfect. Was that done in this case? I don't know. There are no records to indicate that. Well, is that normally done? Yes, it is. Well, if that's normally done, wouldn't you agree it's good medical practice for that doctor to now make a note in the patient's record? Yes. Wouldn't you agree it's good medical practice for that doctor to now make observations about what it is that he or she saw? Yes. Wouldn't it be important for that doctor, that radiologist, to now make entries in the patient's chart indicating what the technician's sonogram showed and comparing it to what they just did? Yes. Can you show me anywhere in this patient's record if there is any indication that any doctor, number one, made any entries in this chart? No, there isn't. And if there are entries that you find, do you see any evidence whatsoever of any observations made by any radiologist? No, I don't. And I asked these questions, these series of questions, to both the technician and to the supervisor. And why was that so important? It was so important because they denied doing anything wrong. So now, when you take my client's testimony where she clearly said that nobody ever came in to examine her after the technician did the ultrasound, the radiology facility clearly violated their own standards, their own protocol and procedure in this particular case. So why do I share this great information with you? I share it with you to give you an idea of one particular case that I handled where I was able to clearly show that the defense violated the basic standards of their own protocol and procedures. And that cost them a significant amount of money when we settled this case. You know, I realize you're watching this because you have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, I do this every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.